So team IT, please indicate to me when you are live.
We are live now, sir.
Okay. Can you hear my voice?
Yes, sir. Perfectly fine.
Okay. Thank you. Thank you. Very good afternoon and welcome to ASSOCHAM Masterclass on M&A. Ladies and gentlemen, as we know that execution of a well-structured deal is an outcome of effective and efficient synergies, excellent knowledge and understanding of entire conversion process, and regulatory compliance mechanism about corporate restructuring M&A deals with the officials of entities under transaction deals. Important is to gaining a strategic advantage in the M&A deals, as it also depends on careful valuation, execution, post-transaction management. So being ASSOCHAM as an industry body, we have been doing many activities in the M&A Council and Task Force we have at ASSOCHAM. This masterclass aims at capacity building of the participants with actionable skills that can be put into practice. We have with us Mr. Pawan Kumar Vijay. He is the chairman, ASSOCHAM Task Force on Corporate Restructuring and M&A and founder Corporate Professionals. We have joined by Advocate GP Madan. He is co-chairman of ASSOCHAM Task Force on Corporate Restructuring and M&A and the managing partner of Madan Law Offices. We welcome both of you, sirs, and we welcome Ms. Rajul Bahura, partner, J. Sagar Associates, Advocates and Solicitors. She will be talking on doing homework and preparation for M&A. Then we have Mr. Sujoy Bhatia, partner, Chandigarh and Mahajan Advocates and Solicitors. He will talk on earn outs in M&A, a tool to retain talent and a weapon to claim indemnification. Now, then we will have, we will be shortly joined by Ms. Sweta Bharti, senior partner, Hammurabi and Solomon Partners, to address the topic of undertaking due diligence and target companies. As a last speaker, we will have Dr. Sanjeev Gemawat. He is the Group General Counsel, Vedanta Group. He will share his vast experience and insights on M&A issues, challenges, and way forward from industry perspectives. So, without doing further delay, I would request and invite Mr. Pawan Kumar Vijay, Chairman, ASSOCHAM Task Force over M&A, to please give your welcome address and opening remarks. Sorry, Sweta Bharti, madam, I couldn't see you. Now I can see you, so you are most welcome in this session. Over to you, Pawan, sir.
All the learned speaker and the participant for this program. This is the first program on virtual. Our special program is virtual masterclass on M&A. We have done so many programs before the COVID, but after the COVID, things have changed. Now we want to bring everything again on the same way, the way we have put in our efforts, and we have organized various programs on M&A. As friends, you are aware that M&A is taking up, not only today, but now it is more. The reason is very simple, because this is a liberalization of Indian economy, and we have seen the large and growing middle class and the globalization ambition of Indian business. These are the factors which are bringing more and more deals, more and more M&A transaction. Now the interesting point is, I was just doing some analysis. We have seen angel seed transaction more than 1,000, VC transaction more than 500, T transaction more than 1,200, and then pre-IPO 6, and this year 6, last year it was 12, and the venture debt, that is 60, and we have seen 39 IPO last year and 36 IPO in SME. So you can understand these types of transactions which are taking place. And if we go to the cross border, we have seen inbound transaction has taken 143, and outbound mean Indian company has gone out, that is 112. And the most important thing is domestic market has taken place. There are 600 deals has taken place. So you can understand this scale is going up. Its scale will not go down because so many reasons are there. One is government policies are changing. They are putting more liberalization. We have seen PLI, we have seen PAM. This is the reason that more and more M&A transactions are growing, and it will grow. Now, question is why the people are doing this? Just simple, because all experts are here. Indian business is growing faster. And when we are saying our GDP is the fastest growing GDP, then it means more and more business will come, and more business will do something organic and inorganic growth. Now we have seen the startup, we are number 3 in a startup. And so many IT companies are acquiring outside India also. Healthcare sector we are seeing, pharma sector we are seeing, consumer related business we are seeing, and then the more and more of financial fintech, that business is taking place. Now, if you see today's program, which we want to focus, the main focus is what homework we have to do. So, as you are aware that M&A transaction is not only a just one aspect you have to see. You have to do the due diligence, you have to do the documentation, and documentations are always different. Then the valuation aspect, the tax planning aspect, then the stamp duty issue, the listed company, they have a different connotation, and there are rules are there. Then if there is a transaction related to court approval, then you have to go there. But majority transaction are non-court basis, where the valuation and due diligence and documentation and tax planning, these are the 4 most important aspects. Now, today's program is very interesting. Then we are talking about earn-out in M&A transaction. Now, there's an interesting point which has come out. You are doing some transaction, that person is going out, but now this is a very relevant phenomena is taking place in the M&A sector. What is happening that we are saying that you are not going out, the seller is not going out. They are saying 3 years you will be with the company, and then because sometimes what is happening, valuation they are asking, and you are not convinced with the valuation. You think that valuation may be good, or future projection which they are talking, it is not achievable. So you can work out this earn-out uh, type of system, where you can do smooth selling, you can retain talent, you can see that 2 years or 3 years future growth you can see, and the right value you can accept. So this is one phenomena in today's session. We are discussing threadbare on this. But in the entire process, the most important thing is due diligence. As I told you, the due diligence is not only a one aspect, say financial due diligence, it's a legal due diligence. The most important, when 2 companies are coming out, then HR issues are there. Third party obligation are there. HR issues in Indian companies also, 2 different culture is there. And if you see, when SBI merged with the other 7 other subsidiaries, the issue came that SBI rules are different, and other banks are rules are different. So this challenge everybody is facing in India. But if it is a cross border, then this challenge multiply in so many ways. Friends, in today's the webinar, we will discuss about the issues, challenges, and way forward. Now, as ASSOCHAM, we are always trying to uh, talk to the regulator, suggest regulator that what are the changes you have to bring out. The most important thing which we want to see this, and today's all the learned speaker should deliberate on this part. So whatever your issues are coming out, these issues we will compile and send it to the different regulator. Today, when you are doing deal, M&A transaction, it is not only between 2 companies. It is sometime you have to take approval of government, you have to approval of various ministries, you have to take the listing segment, you have to take approval of SEBI, stock exchange, and then if the court related, then you have to go to NCLT. Now, all these things are there. Today in India, if you see, our regulatory process is very complex. It should be changed. It should be modified. And the biggest problem is funding. In India, we are not a level playing field, because what is happening in Indian, no banks can give you the acquisition fund. And if there is a foreign company, They have a fund and they are doing. But now India is also changing because so many new NBFC, so many new people are coming and they are giving the solution. But everybody cannot get this. If the government can do some changes, it will be better. Then challenge, the different culture is there, that you have to work out how you can take the help of the HR people, and then various issues which we have seen, uh, which is related to tax planning issue, related to the legal aspect, where Madan can also say this. The different NCLT practices are there. NCLT process is taking too much time. SEBI is also taking time. So entire thing is there, which creating some issues, and so we should work out some solution. So my request to all the speaker, that they can give their presentation, but at the end, the ASSOCHAM role will start when you are raising some point, and that point we are referring to the respective regulator. It will be helpful and it will be really fulfill the purpose of this webinar. Way forward, I'm thinking future is bright, and the way things are moving, it will it will be a difference in the game field. Foreign funds are coming, foreign people are coming, and Indian companies are also in the mood of acquiring more and more business. Organic, inorganic growth is taking place, and the hunger of Indian business is growing, and they are becoming big because they have to compete. That's why we are seeing in the government sector also, government, the DPAM is doing merger of various government companies, and they want to make one. And I can see this in future. We may have only one bank in India in a public sector and multiple bank in private sector, but these private sector bank will also merge, which we have seen. So this increasing globalization, Indian economy is growing, and ability to have capital. These are the three segment, three aspects will bring more and more business and more and more amenity. We are here as a SOCHM committee. Whenever you have any issue, whenever there any issue relating to regulator, which is impacting everybody, we will raise your point. With these things, thank you very much. Over to you, Santosh.
Thank you, sir, Pawan sir. Now, may I request Advocate GP Madan sir, Task Force Co-Chairman, to please take over your discussion points. I invite you, sir. Over to you.
Thank you, Santosh. I welcome all the panelists present here and all the participants. And we're really thrilled to see the number of participants right now, 240 in number. Santosh, full credit goes to you and your team. The way you have structured your program, and I'm really thrilled to see that, we started these events sometimes more than a decade ago, sometime in 2011-12, if I remember correctly. That time we named these programs as M&A tool for wealth creation or for value creation or value unlocking. But this time I'm really excited that you have named it a master class. And you have invited who has who from the professionals and experts in the field. The four I can see in the program sheet. And the way you have structured the topics, I'm really excited that after this, maybe around 6:30, whenever you're going to close it, everybody will be very, very enriched with the outcome of this particular masterclass. As Mr. Pawan also described about M&A activities, last year has been no doubt very, very robust for India. Wherever India was there, whether they were inbound or outbound transactions involving India. But recently there was a report that current 2 years were very bad. Current 2 months of the year, calendar year 2023 were bad. There may be reasons for that. We may not be that bad in comparison to other countries in the world. We were bad when we compare ourselves with 2022. But the reasons may not be internal, reasons may be external also. External reason, we have seen that global markets turmoil during last 2 months. Internal reasons, many people say that because of their people raising questions on the valuation. Only with respect to a report which was released on the valuation of one of the largest groups. And now the foreign funds might be raising certain issues on the valuations, whether the valuations with the Indian ventures are carrying, are these valuations are accurate or not? Do we have to something to redo with this valuation? So these issues may actually derail the M&A activities for the time being. But ultimately, by the end of the year 2023, I'm pretty sure that we might have better figures than 2022. Coming to some of the issues, regulatory challenges, because I being a lawyer, I normally deal with the regulatory issues in M&A. Certainly, we need to do a lot. Mr. Pawan refer about the NCLT practices. I tell you, NCLT practices across the benches in India is very, very different. Even in Delhi also, we have 6 benches and 6 benches are having different practices of M&A approvals. First motion, second motion, in between. It is taking not less than 1.5 years to 2 years to approve a scheme of merger. And some of the lawyers are actually saying that earlier regime of going to High Court was much better than NCLT. Recently from our bar, we have met NCLT president also. We have suggested that some designated benches should be there to approve M&A cases. And NCLT president actually has given us an assurance that he will look into this. And definitely the moment the adequate number of members are there in the benches, this issue will be taken up on priority and we will see the designated benches in M&A. You know, as on it, what is happening, you file some scheme and now you seek the approval. First of all, we need to see whether there is meetings can be dispensed with or not. Despite we have jurisprudence on our side, even if there is a merger of the holding company with its only owned subsidiary companies or vice versa, despite we have jurisprudence, but still the bench is saying, okay, hold the meetings, which to begin with delays the process for at least 4 to 5 months. You have to have the meeting and it becomes a very, very expensive also. Then you file a second motion. You keep on waiting for the report of the regional director and the official liquidator. Reports are not coming forward. Income tax authority, you keep on giving the reminder, they'll not come forward. All your tax dues are on time. You have filed the returns. No assessment is pending. Still report is not coming forward. Then ultimately you have to give an affidavit, come undertaking or indemnity that whatever shall be the outstanding due. If any demand is there in future, the transferring company shall be a bear. That is, transferring company undertakes to pay all those liabilities. Another thing what we have seen recently is while if there are large number, the transaction amount is large and competition commission also comes into picture, we have to be very, very vigilant. Whether this merger scheme is going to be anti-competitive or some sort of dominance is being created. No doubt the recent order of Google has got nothing to do with M&A, but that may have impact on M&A. The 1,300 crores of the penalties which have been imposed, because it has been said by Competition Commission of India that there has been abuse of dominance. I'm not going to marriage, but the penalties, the amount of penalties which is being imposed by Competition Commission of India may act as a deterrent. Further, the competition amendment bill, which has been recently passed by Lok Sabha. Now, the penalties may be imposed on the basis of the global turnover. Earlier, it was based on the turnover of the Indian company. Now, it will be based on the global turnover. Now, suppose you are having 10% of the turnover in India, 90% is outside India. And if penalty amount is levied on the basis of percentage of the 100% of the turnover, it may be too huge. But no doubt, with the help of we professionals, with the help of we, the professionals, certainly if we provide best of the guidance and all these schemes go through and we don't find, we ensure that there will not be any non-compliance, there will not be any contravention. All the regulatory provisions, all the provisions, rules, regulations shall be complied with. Certainly, we can save all these companies from many penalties. Uh, but as I said in the beginning, that I am very, very bullish about this M&A activities in India because recently we have seen our neighbor's loss is our gain. Certain policies which have been there in our neighboring countries. I'm not specific about one particular country, no doubt their loss is our gain. But the way the other countries are performing nowadays, the economy of the other countries, certainly the other maybe the biggies will not be going to these countries. If they come to Asia, certainly they'll be coming to us. And in the coming years, in coming months, I'm really expecting a big chunk of money flowing into India. There will be more and more acquisition. There may be more and more mergers. And I, being an insolvency lawyer, also, I'll say under Insolvency and Bankruptcy Code 2, there are many M&A opportunities. Whether it's as by way of resolution plan, whether it's under liquidation, and I'll say even before commencement of insolvency resolution process, there are opportunities. Because the moment a company goes into default or the bank issues any notice for recovery, these companies, if they are think that they cannot meet their default, if they cannot make the payments to the creditors, certainly they'll be looking for the M&A activities. If some sort of mergers can happen, some sort of acquisition can happen, some sort of buyout or sellout deals may be there. So, opportunities are there everywhere. Only thing is that we need to encash these opportunities. And I'm sure our expert panels today, 3 of them are already here. I know them personally also. They will be certainly looking into all these issues which are being raised. And I really like the topics which you have assigned, Santosh, with particularly the due diligence given to Shweta ji, one of the seasoned professionals. And I really like this particular, what we have given to Mr. Sujoy Bhatia. Earnouts and M&A, a tool to retain talent and a weapon to claim indemnification. Fantastic. I don't know where from you have taken these words, whether Sujoya suggested to you or you have taken from your own. But actually, because of this, earlier I thought I may not be present throughout the session, but now I've decided that I'll remain present throughout this entire masterclass. Thank you very much. Thank you all. And I wish that this entire masterclass will be very, very enriching for all the now 262 participants. Thank you.
Very much, Madan sir, for your kind enlightening words. And now I take opportunity of inviting Ms. Rajal Bohra. She's partner with J. Sagar Associates, Advocates and Solicitors to speak on doing homework and preparation for M&A. So over to you, Ms. Rajal.
Many thanks, Santosh. So I would first of all like to thank everyone, ASSOCHAM, Mr. Santosh, Jatin, for having me here. It's really a pleasure to take this and to be a part of this masterclass. The topic that has been given to me is doing homework and preparation for an M&A. I'll just take 10 seconds to just display my presentation and then we can get started.
Hey, Mikey, can you give the sharing rights to Rajulji?
Okay, is it visible now, Chad?
Yes, you are visible, audible as well.
Okay.
Perfectly fine. Thank you. Please go ahead.
All right, so the topic is getting M&A ready. There is lots to do when a particular company decides that they need to go for a mergers acquisition deal, whether it's whether as a buyer or as a seller. There is lots to do. So in the time that I have decided to kind of go step by step on what are the things that any acquirer or a seller would want to be M&A ready in terms of things that are in place, because we have to understand that deal starts with identifying the target, identifying the buyer, but there are various challenges that are involved as we go from stage one to the final stage. And we understand that it is not just the two companies that will be working on this. There will be externalities, there will be authorities that will be involved. We may have to go to courts. And keeping this in mind, there is lots to do in terms of homework, I would say. Let's start from the first one. There will be, obviously, the first thing is to know that.
Rajulji, sorry to disrupt. Can I request to please make slides full? Present the.
Oh yeah, sure.
Yeah.
Okay, so the first thing is to know and identify who is the company, which is the company, who are the promoters, who are you acquiring, whether it is a buyer who's going to acquire or the seller who will be selling. It is very important to know the kind of company, the promoters you are dealing with. So while it was a thing of past that you would just identify someone and start working on the deal, what we've seen as legal advisors, that it is very important to do background checks of what company are you diligencing. At least whatever information is available in the public domain, you may want to know what promoters are you dealing with, what kind of history they have, is there anything available in the information that is available publicly, whether there are any records in terms of have they been involved in certain issues. So it just gives you the step one to know who you are dealing with. Once that has been done and you've identified, you've done your background check, then it's obviously time to enter into negotiations. This will be the initial stage of negotiations. But then understanding what are the broad commercial terms on which you want to close the deal, what sort of goals are in the mind of both the parties in terms of how do they want to complete a particular M&A transaction, whether it is the consideration or what business are we looking at, what are the goals that both parties have. Moving on, the next thing would be to really have a team set up, understanding who would be the advisors, what sort of team you would need for this sort of transaction. Here, obviously, it is important to know that what is the kind of industry that you are in, and therefore keeping that in mind, you may have to appoint more and more advisors. You would need investment bankers, you would need legal advisors, tax, financial advisors, valuers may need to be appointed. And obviously, once that is done, then a budget for the costs, because that also then becomes a big issue for companies to understand what is the cost that are involved in terms of hiring the advisors that they would need. Here it is obviously what we've seen when we are working with companies, that these sort of budgets are done in phases, so that at any stage of a transaction, if you want to withdraw, you don't want to go ahead, then you have those fees, the fees and budgets that are split into phases. Getting on to the next step will be to set the timelines for a transaction. While you have decided that, yes, I'm going to be doing so-and-so transaction with a particular company, you need to obviously have an overall time in mind, because time, money, effort is going to go. You are obviously, if you're spending months and months doing a particular deal, then there is an opportunity cost as well that needs to be seen. So due diligence, timelines, when will the execution happen for the transaction documents, when the closing will happen. So that needs to be estimated at least, and a timeline has to be agreed between both parties. This can then be shared with advisors just to have everybody on the same page. So this basically, when we are talking about how to get yourself M&A ready, this is more for general counsels, for legal teams, for advisors, for business teams who are working on such M&A deals. So therefore, I've kept the presentation from all the perspectives in mind. The next would be obviously to understand the legal landscape that is involved. So while you are doing an M&A deal and being a legal advisor or legal practitioner on this subject, what we have seen is that sometimes business teams, finance teams don't want to understand the legal landscape in the beginning, and they want to go ahead and start signing documents. The suggestion always is to understand what is the kind of legal landscape that is involved. Are you going to be dealing with a non-resident entity? If you are a company incorporated in India, if you're sellers of a company here in India, and you will be dealing with acquirers who are outside India, then you need to also understand FEMA considerations involved. What sort of structure can you have for this? So therefore, it is important to at least have a broad idea of the legal landscape that is involved. And once that is there, there are certain shareholding restrictions that could be there in the sector that you are in. If it is pharma, then there are certain restrictions. Insurance sector has certain restrictions. Understand which sector are you operating in and what sort of laws do we have in India in terms of having investments in. There could be regulatory approvals that could be involved. So in the beginning, if you've decided that you will be selling 100% of the shares of the company, you know that it is a regulated industry that you are in. So understanding what sort of approvals are required from regulatory authorities. And like Mr. Madan said, that these approvals sometimes can take forever, and you may have to then see whether you want to go ahead with this deal also or not, because there are a lot of considerations involved. So therefore, at least to have a broad idea on what sort of timeline are we looking at, speaking to the advisors and understanding what is their experience, recent experience with such regulatory authorities. So therefore, that also becomes important. Even in terms of flow of consideration, if there is a non-resident entity involved, then how should the money come in? In what stages can the money be split in terms of the closings that you have to do? How much percentage is being sold? So just an idea of the structure, it's just understand the legal landscape involved. Because as we all know, there is lots that we have to plan, and therefore it's good to have and know what sort of legal obstacles that can come in between. Then moving on, a very important aspect in what is confidentiality. Both parties need to understand that any sort of information that is being exchanged between the parties, even while the deal is under negotiation, has to be protected, and therefore it is always recommended to have a non-disclosure agreement in place where parties agree that nothing would be shared, and then there will be also non-solicit obligations on the acquirer, which means that they cannot approach the employees of the target company if the deal does not go through. So there will be a non-disclosure agreement. And then once we have a broad idea of where the transaction is in terms of whether we are buying a particular company, in terms of the acquisition business of the company, at least whatever basic key terms that have been agreed between the parties, it is a good idea to have them recorded in a term sheet. A term sheet can be a binding term sheet or a non-binding term sheet, depending on what the parties are looking at in terms of the goals. Whether they want the other party to be bound by certain terms, at least for a limited period. So we can have a term of the term sheet, which will say that for 6 months, we will work together to close this deal, so that you are secured that both parties want the deal to happen, and therefore they are working towards it, towards each other. There could be exclusivity clauses, due diligence, timelines, definitive documents, when should they be signed. There could be a break fee, which means that after we have done everything, if we are not able to do, there will be a break fee payable. There should be long stop date to close the transaction so that there is visibility of timeline on both sides. And then how would the transaction cost be split? Once we've done all of this, the basic preparation, then comes the next stage where we try to identify the best structure that we would want to do for the particular M&A deal. While you may have a bit of an idea about the structure in the beginning only, it depends. Sometimes we are not sure on what structure we want, whether we want to buy a company is all we know, whether we want to buy it by way of buying the shares of the company, or we want to buy the business itself or certain assets itself. We may want to take this decision once we've seen some information, once we've done some diligence, or once we've done some discussions and negotiations along with the advisors. So it could be a share purchase transaction, like I mentioned. It could be a business transfer, or it could be a approved merger through courts, which is the NCLT merger process. We need to understand that any of these structures that we choose, there could be a lot of factors involved in how we want to choose the best structure. There could be tax considerations involved if you want to do a there could be less tax, it could be tax neutral if we are able to meet certain conditions under the law. Obviously, if there is a share purchase, then there will be income tax involved in terms of the seller who's going to sell the share. So tax considerations are one of the most important considerations when deciding a structure. The tax authorities have been very active since past few years, as we all know, with respect to any sort of assets indirectly being acquired in India. Also, in terms of cross-border mergers, has been looked at very actively by authorities. So therefore, we need to see all sorts of tax considerations involved, withholding tax that is involved. So it is important for the buyer and seller to be on the same page in terms of tax residency, withholding tax. Then comes the nature of target, what sort of business structure and organization it is. That also plays a role in terms of deciding a structure. What are the assets that we are looking at? What liabilities we would want to avoid? What kind of employees are the kind of asset which we are targeting for the company? How would that be best acquired? Due diligence issues that we may have seen or which we could see later, and it is possible that we may identify a particular structure. We may identify a particular structure in the beginning, but later, because of the due diligence issues that come out, we may have to change the structure. So that can also happen once we've done the diligence. Nature of acquirer, it's a foreign entity, it's a domestic entity. That also plays a role in terms of structure, because if you have to do an asset transfer or a business transfer, you would need the buyer to be in India. So that is also important. There are additional factors in case of cross-border transactions that will have to be seen, because there are restrictions in terms of escrowing the consideration. So that is also one of the reasons why would you want to choose a particular structure. Once the structure is decided, the structure can either be documented in the term sheet if it was decided by the time the term sheet was being executed. If it is not, then typically in the term sheet, we see a clause saying that it would be the most tax efficient structure that will be appointed, or tax and regulatory efficient. So these sort of broad clauses are included in the term sheet if it is not decided before. Once the structure is identified, then at least agreeing on the documentation. We may want to start the documentation then and there along with the due diligence parallelly, depending on what is the comfort that we have with the other party, or we may want to first complete the due diligence and then move on to the documentation, because we would want to see what sort of issues are coming in the company. So it completely depends on the comfort of the parties and what sort of issues they have already seen in the company. But at least it's a good idea to have a list of documents ready so that everybody is on the same page in terms of the documents that will be required for a particular transaction. It could be a share purchase agreement, it could be a shareholders agreement, or a share subscription agreement, a business transfer agreement, employment agreements that you may need with the promoters, because post acquiring the company, you may want them to serve as employees for key roles for a particular time in the company. So you may want to decide, depending on the structure that has been agreed, what sort of documents will be executed. You also need to assess the deal certainty and include the clauses that are needed for protection. Because we may be, the parties are investing good 6, 9, 12 months, depending on the kind of CPs that have been agreed on, what sort of conditions that will have to be completed before the deal is closed. So keeping that in mind, you may want to include certain clauses for protection of the deal certainty. Then comes the due diligence, which obviously is a very important stage for an M&A transaction. Both the buyer and the seller needs to be ready and prepared for the diligence. In fact, it's more for the seller to be prepared, because the company that is being sold or that is being bought will be diligenced by the buyer. So the acquirer generally conducts legal diligences, financial, tax, technical. It is a good idea to agree on a timeline for completion of diligence, because sometimes it runs over months, and that is not an efficient thing for a transaction. So therefore, a pre-agreed timeline which can be documented in a term sheet is a good idea. The seller then needs to decide how to set up the data room. We also see at times that such seller companies come to legal advisors, tax advisors in advance, and they say that we want to do the due diligence before we start with the transaction or before we identify the buyer, so that we are ready when the buyer has to start the diligence. So therefore, a vendor diligence is also very common. But once you've decided that a diligence will be done by the buyer, will be coming and doing the diligence, whether it will be a virtual diligence or a physical diligence, there are virtual data rooms, facilities that are available, so people may want to do that. And then it is on the seller to collate the data. It's obviously a good idea to have a strategy on how the data has to be shared, presented. It's a good idea to consult with legal teams before sharing data. So those are the things that have to be planned for the due diligence. Now moving on to so once we've done the diligence, we've come to the next stage where we've obviously kind of understood the business, the company, the compliances that the company has been doing, if there have been certain issues in terms of not getting certain approvals. So there is a time when we are able to make a list of what sort of due diligence issues have we come up with, what are the conditions precedent, which means that those action items which the seller or the target company will have to complete before the buyer will come and complete the transaction, before the buyer will make the payment. So therefore, those issues are identified. It is then negotiated and agreed whether those will be done before the execution of the documents or before the closing of the transaction. Because between the signing and the closing of the transaction, we do keep a timeline in mind, depending on the kind of issues that have been highlighted in the DP, on how much time will it take for those issues to be rectified by the company or the promoters. So, but if there are times when we are not able to agree on the condition precedents and we feel that those are not so important to hold up the transaction, then we can make it condition subsequent. But I mean, it is obvious that we will not be able to make those conditions precedent or condition subsequent, which are coming from law. If regulatory approvals are required, or if any consent has to be taken from a third party prior to doing the transaction, prior to the change of control happening, or prior to the shareholding changing, then in that case, those action items will in any case have to be done as condition precedent. So they will have to be negotiated as such. We've also seen parties agreeing on timeline for each CPs, so that it doesn't happen that after 6 months, which we have put in a period between signing and closing, in the 6th month, we are getting to know that 80% condition precedents have not been satisfied. So that is also a way of controlling, because we all need to remember that as the time is passing, there is a cost that is being incurred by both parties. So therefore, it's a good idea to keep an eye on how the CPs are being completed by the target. We obviously have the whole list of approvals ready in terms of what all needs to be taken from statutory authorities or from third parties, whether it's pursuant to contracts that the company has signed or then comes the negotiation on the transaction documents. This obviously can take days, weeks, and months, depending on what sort of negotiations that are happening in terms of clauses, whether expectations are aligned, whether pre-closing items such as condition precedents or post-closing action items with respect to how adjustments will happen, the purchase consideration, the valuations will be agreed. So negotiation obviously is a completely different topic. I will not go into detail of that, but just so that just to discuss key terms, what would be the reps and warranties that the buyer would need from the seller, from the company, the indemnities that will be required, so that tomorrow, if any liability comes up, which the buyer was not made aware of, or for any period before the buyer comes in, then all that has to be given protection by the seller. We have fundamental representations, which are very fundamental. So if I'm buying the shares of the company, the title of the shares has to be clean. So that is a fundamental representation. Business representations would basically mean how the business is being run, what sort of compliances are being done, taxes are filed. So all that will be required. If you're buying the land of a company, you're buying shares of the company, then those representations are extremely important in terms of title related representations. Then we need to see what is the purchase price that is there in terms of how it needs to be closed, the pre and post closing adjustments to the purchase price based on the information that we come across in while doing the diligence. So that is also one area that needs to be discussed and documented in the documents. Then there are employee considerations involved. We need to review the employment contracts because HR becomes a very important role. It plays a very important role when we are doing an M&A transaction, because integration of the employees make sure that all policies are aligned. And once the buyer company acquires the seller company, then how is the transition done for the employees? If there are any changes to the terms of employment contracts, do we need to take prior consent from employees? So that also becomes very important. Then we go on, finally, once we have negotiated, we've agreed on everything, we execute the transaction documents, understand how do we go about the execution, the stamp duties, the authorizations that the company needs to sign the documents. There are interim provisions in terms of how you want to protect the business between the signing and closing. So that needs to be honored by the sellers and the target company, that they don't do anything which is not an ordinary course of business once the execution has been done of the deal. Then comes the closing, where you have to pay the purchase price, you have to convene meetings, you have to align teams, because that is the day when merger and acquisition transaction will be considered completed. So lots of preparation needs to be obviously done for the closing in advance. And then comes the post M&A integration and action items. This again requires preparation. So this needs, there needs to be an integration of finance, of the finance teams, the employment bit, which we discussed some time back, then the IT systems, the policies of both companies. So it is very important that the effort and time that has gone for doing an M&A transaction, if not more, at least the same sort of effort is also put in for post M&A integration, because we've seen that there are fallouts in terms of how the companies have been integrated, employee fallouts. So therefore, it is very important that that is also handled. This is a bit on the scope of due diligence. I will not get into the details of it, but just a bird's eye view of what sort of diligences that are important. How you should be preparing for the negotiations, understanding the facts of the company, what is the goal of the negotiation, is there any commercial points that gives you a leverage when you are negotiating? Is there something which you understand is non-negotiable for the company? What is the best alternative to a negotiated agreement, which means that if you do not get the best thing that you're looking for, what is the second best alternative that you will be okay with? And then understanding that you cannot do a particular deal because the negotiation cannot be concluded even on that best alternative. So preparing for negotiations is also an angle to it. Looking at the time, I have kind of been a bit rushed on the last slide, but I just wanted to talk briefly about the challenges that are generally faced. The kind of challenges that we generally see are on the regulatory sides, the kind of time that is being taken by regulatory authorities. So it is very important that the documentation that needs to be filed with the regulatory authorities is done in a proper manner. And we need to factor in that, like, for example, if the case is with the NCLT, like Mr. Madan said, that whether, because it is with an external authority, the timelines could push. So the business needs to be prepared for it in terms of how much time it is taking. Then there are challenges with respect to employment that we just talked about. So it needs to be ensured that the employee consents are being taken in time, especially if the employees have to move from one company to the other company. That is another challenge that has to be seen. Also, in terms of understanding the expectations of both parties, where is it that they can negotiate what they can't? So that is also, having an alignment on the expectations of the legal negotiating for you also make to understand that what is it that you really want from this deal. You can't have the negotiations go on, because there is a time when we have to understand that we have to give up a point, or we wanted something and hence we want to have a strategy towards a negotiation. So very important to prepare the advisors, because we've seen that sometimes the deal has fallen through because the advisors wanted a point which the business did not want. So therefore it is very important to align the advisors as well, so that they are all aligned in terms of timeline. And any M&A deal, I would say, is not just dependent, like I said, on the two companies or on the management of the two companies. It actually requires alignment on all sides, whether it's advisors, regulatory authorities. So preparing well for an M&A deal will basically mean that the post M&A integration is also done well. And that to me is a successful M&A deal, not once it is closed, but once it is integrated well. And once time has passed and both the companies which have merged or a company that has been acquired is still sustaining and doing the kind of performance that the buyer expected it to do. So I would just now take a pause and just ask if there are any questions.
Thank you, Rajulji, for your elaborative and kind address on the subject. Very comprehensive to set the tone of this masterclass. Indeed, it's a great contribution from your side. Now, I take the opportunity of inviting Mr. Sujay Bhatia, partner, Chandigarh Mahajan Advocates and Solicitors, to please share your views, perspectives on earn-outs in M&A, a tool to retain talent and a weapon to claim indemnifications. It's the most appreciated in the masterclass by the chairperson, council chairperson as well, one of the important topic rather. So over to you, Mr. Bhatia.
Thank you, Santosh. First of all, thank you to Santosh and Jatin at the ASSOCHAM team for giving us the opportunity to present our views. And also many thanks to my co-panelists for joining in. Rajul, I heard your slides and your presentation with great interest, and I'm sure that there will be questions later on. So if you allow me 5 seconds, I'll present my slides as well, and we can then commence.
Jatin and Vikas, do you have your the PPTs of Mr. Bhatia? Can you please run through?
I think I do have the ability to share now, so let me see if this works. Are you able to see my slides?
Yes, we can see, sir. If you can please zoom out or make full screen.
Does that work?
Yes, this is
Perfect.
fine now.
Okay, so the intention from my side today is to briefly talk to everyone about the concept of earnouts and deferred consideration in M&A. Rajul very kindly set the tone around how you prepare for an M&A activity. But what happens in a lot of slightly complicated mergers and acquisitions in India is that the purchaser isn't quite sure what the correct value of the entity the purchaser is buying. So let's say I'm the acquirer and I'm interested in acquiring company X. The seller for company X believes that it's valued at 1 crore rupees, but I'm not sure. From my perspective, it is probably valued at maybe 75 lakhs or 80 lakhs. But we are not able to come to an agreement on the price. So what do? What we do is we essentially pick one of two options. Option number one, or an earnout, is in many ways a positive way of doing things. So what the earnout essentially means is that I, as the purchaser, I'm saying that, okay, fine. I believe this company is worth 1 crore. So here's 1 crore that I'm paying to you. But if in a certain point of time in the future, the performance of the company is better than I expected, I'll be happy to pay you another 20 lakhs. So both parties on day one agree a price and then say that, okay, if performance or if certain aspects are better than expected, there will literally be an additional earning or earn out that the sellers of that business make as a result of such positive agreement. So this is essentially a tool in the hands of the purchaser to agree with the seller that, okay, you believe that your business is great and that it's going to do really well in the next 24 months. So let's agree today that I'll pay you X sum, but that if the business does well, I'll pay you a bit more. That performance parameter, of course, needs to be objective in nature. So you will need to agree in advance that, let's say your revenue was a certain number on the day I bought the business. But if the revenue went up by a certain multiple in the future, I would pay you some more money. On the other hand, if it's a customer-centric business, and we've agreed that on the day I bought the business, there were 1 million customers, and you normally expect the business to grow 10%, so that you'd have 1.1 million customers in 1 year. However, if the business grows 20%, I'll pay you some more money. So these are all positive statements, right? This is both parties coming together and agreeing that, okay, if things happen better than expected, here's some more money. On the other hand, a holdback is more of a weapon. A holdback typically arises in a scenario where I, as the purchaser, have some doubts about the business. So in the scenario that we discussed, you and I agreed 1 crore as the price, but I'm not sure, right? Maybe there's some massive litigation that the company is involved in. Maybe there is a contract with an important vendor or an important customer, which could get terminated as soon as I buy. Or there are certain other reasons which could seriously impact the viability of the business going forward. So you see the tone here or the tenor here of the discussion is slightly negative, which is that I, as the purchaser, am slightly concerned that there might be an issue. I can't put my finger on it, but I can definitely agree with the seller that if this issue arises, we will have to figure out a way to solve it. So that's where the holdback comes into question. So in our example of a business worth 1 crore, what I would do is I would say that, okay, we've agreed today on paper that the price is 1 crore, but I'm going to hold back 20%, for example, or 20 lakhs. I'm going to keep that 20 lakhs with me. Here's 80 lakhs and off you go. If tomorrow there's an issue, let's say there was a litigation which results in a claim against the company. Now, clearly, I, as the purchaser, was not responsible for that litigation, right? It was the seller when he or she was in control of that company. So I would then use that amount that I've held back to pay for that litigation. So to put it simply, when you're looking at, generally speaking, and this is not really law, what we're discussing here, this is more market perception and the terms that are generally used in discussions. So generally speaking, as a thumb rule, if you're looking at positive statements around revenue improving more than expected, customers improving more than expected, IP being created, for example, those are typically tools which are to the mutual benefit of both parties, right? So in the example, our revenue shot up. So now I'm happy to share a portion of that upside with you as the seller. So everybody goes home happier than they were earlier. However, in a holdback scenario, that's a more of a negative context, right? Because we've realized in a holdback that there was a litigation which you as the seller told me was not going to be a problem, but it did end up being a problem. And therefore, I am now holding back the 20 lakhs that I was supposed to pay to you. And you sort of go away unhappy as the seller because you expected to receive a crore, but only got 80 lakhs. Now, how does this work in practice? In a domestic M&A transaction, and by domestic, I mean there are no foreign parties involved, either as a buyer or seller, or even as the parent entities of buyers and sellers. So the entire transaction is happening in India between domestic Indian parties, which also, and this is important here, which also do not have a foreign parent. And I'll come to it later as to how the importance of, or the reason why a foreign parent becomes relevant in the context of earnouts and deferred consideration or holdback. So we're right now talking purely of a rupee transaction in India between purely Indian parties who have no foreign shareholders. Okay. Now, in a domestic scenario, I could do both. I could agree an earnout. I could say that there's a future payment of X within Y time. It would be subject to meeting milestones. On a holdback, I could agree a percentage of the consideration that I paid, and that would again be subject to meeting or not meeting conditions. So the limited point I'm making here is that the distinction I've drawn right now between an earnout and a holdback being more of a positive statement vis-a-vis being more of a negative issue applies purely in a domestic M&A scenario. However, when you move to a cross-border M&A scenario, that's where things start getting interesting. In a cross-border M&A scenario, because the Reserve Bank of India gets involved, any payments of money from or to India are regulated under the Foreign Exchange Management Act. Now, the Foreign Exchange Management Act stipulates very simply that you can do a holdback of the overall consideration, but it cannot exceed 25% of the total amount of money that you agreed to pay. So in a domestic M&A, let's say in our example of a business worth a crore, I could decide to hold back 50 lakhs, and there would be no issues with that. But in a cross-border scenario, the law stipulates that you cannot hold back more than 25% of the total consideration. The other restriction in law is that such holdback cannot be withheld for more than 18 months from the date on which you enter into the relevant agreements. Now, in a domestic M&A scenario, I could, say that, okay, fine, I'm holding back 30% of the 1 crore, so 30 lakhs, and I will pay you this money 5 years later, for example. Because as we all know, litigation in India can take a lot of time. So if there was this massive litigation in which the company was involved, I want to be sure that that litigation is closed before I pay the balance amount. And I anticipate that this particular litigation could take 3 to 4 years to resolve. So I say that, okay, I'm holding back 50 lakhs and I'm going to pay you that 50 lakhs subject to the litigation being resolved in 4 years. The key point here is that you cannot do this in a cross-border M&A. The other interesting point, and this my friends on this call and co-panelists who would have worked on cross-border M&A would know this well. India's regulations also prescribe what are called pricing guidelines around cross-border M&A. India traditionally has been a conservative nation as far as the flow of foreign exchange is concerned. So the Reserve Bank of India is very interested in transactions or scenarios where dollars or money is leaving the country. So whenever anybody on this call, on this webinar is participating in a cross-border M&A, the first thing you need to look at is money entering the country or is money leaving the country? If money is leaving the country, please note that the RBI believes that there should be a control on the amount of money leaving the country. And therefore, the RBI prescribes what are called pricing guidelines, which is that if I am a foreign party and if I am selling something to an Indian party, obviously that Indian party will pay money to me overseas. So therefore, money is leaving the country. The price that the Indian party will pay for that transaction is capped at a methodology which the RBI prescribes. Essentially, it is fair market value, for lack of better word. So, and this is important here, and want everybody to pay attention to this because it becomes very relevant in the subsequent slides. In a scenario where money is leaving the country, pricing guidelines prescribe that you cannot send more money greater than the fair market value of the shares as arrived at by a certified chartered accountant. Okay. Now, let's see how this becomes relevant. You are buying my company. The price is a crore. However, I agree a holdback, right? And that holdback is, let's say, 15 lakh rupees. However, the pricing guidelines state that the total price that can be paid for this business is 110 lakhs or 1.1 crores. So you and I cannot agree a deferred consideration of 115 because the law stops you from doing so. So not only is there a restriction under Indian law to the percentage of the consideration, to the time for which you can hold back the consideration, but also in a scenario where money is leaving the country, the maximum amount to which you can agree that holdback. We'll talk about this a bit more when I come to the relevant slide. I now want to switch focus a little bit on certain creative structures that have come into the market around trying to implement earnouts and holdback. So as we discussed a few minutes ago, one of the main advantages of an earnout is that you can agree milestones. What you can do and what is particularly relevant in a startup scenario, in a founder-driven business, for example, is that you can retain management. So let's say I am a private equity fund, right? I want to buy a large Indian business that is owned by founders in India or promoters in India. Those founders have traditionally run that business for the past 10, 15 years. And the business is known in their name, right? So let's say, for example, it's a food manufacturer or a fast food manufacturer, right? That fast food manufacturer is known because of the recipes that the family passed on generation to generation. Now I, as a private equity house, have come in and said that, look, I see there is a lot of value in this business. We should modernize it. We should take it nationwide. So I'd like to buy this business, right? And let's expand our example a little bit. Let's say this is worth now 1,000 crores. Okay. In that scenario, I, as a private equity house, say that I want the whole shebang. I want the whole company. So I'm willing to put 1,000 crores on the table for you to sell this company to me. But I realized as the private equity house that I could pay the 1,000 crores, get the company, but if the promoters leave or if the founders leave the business, the customer is going to realize that the guys who ran the recipes, or the guys who ran the kitchens for the past 80 years, for example, are no longer part of the business. So A, I might lose customers. B, and what is a greater risk in India, the promoters or founders could just start a new fast food business or a food manufacturing business the next day. So I pay them 1,000 crores to effectively set up a business that competes with me, right? Let me go through this example again. They pay these guys, Mr. X and Mr. Y, right? The two brothers, they run a great food manufacturing business. I pay them 1,000 crores, they sell their company to me. I, as a private equity player, am now the owner of this large food manufacturing business. Mr. X and Mr. Y, the next day announce the setting up of a new food manufacturing business, making exactly the same kind of food in the same markets. So I've basically shot myself in the foot here, right? Because I paid somebody 1,000 crores to set up a business that competes with me. Now, somebody would argue that you could enter into a contract with these individuals and tell them that you will not compete with us for a certain period of time. But let's be realistic, right? This is India. Yes, some amount of non-competes recently courts have held could be enforceable given circumstances. But I would be highly surprised if you could end up getting a strong non-compete through courts in India. So what is the solution? The solution is an earn-out. The solution is a holdback. So what do you do? Either we do what we discussed earlier, that we pay them only 800 crores and tell them that we'll pay you 200 crores 2 years later, 18 months later, 3 years later, as the law allows. On the other hand, you could structure this as a contractual earnout, which is that you make these two individuals this joint managing directors or joint CEOs of this business and say that 200 crores is now earmarked as bonus for management retention. Now, this has tax implications, of course, because what was earlier being paid to these individuals for share purchase will now constitute income for them. But as an investor or as a purchaser, I now have the comfort that these individuals are not only going to remain in the business, they are going to work hard to grow it further. And my customers continue to remain happy because they see these guys continuing to run the business. So that's one advantage, right? Now let's flip it over and we will be discussing earnouts, positivity. Okay, you guys are the promoters, continue with us for 2 more years. You'll make another 200 crores and customers will be happy. It's all good. Now let's talk about the holdback. I, as the investor in this example, know that there have been investigations by the Food Safety Authority against this company. I know that certain consumers have filed cases for food poisoning against these people. So now I'm concerned, right? That let's say I buy the business and there's some skeletons in the closet, and as a result of which my money is going to go down the drain. But the founders, the promoters believe that there's nothing wrong, right? They have a distinct advantage in staying on board. And that advantage is that they can manage the business and affairs of the company going forward together with the investor. And they'll know that the investor is not intentionally going to, for lack of a better word, cheat them out of their assured holdback amount. So there is a check and balance in place. So where I contractually agree that, okay, 200 crores becomes payable to you 2 years later, I, as the guy who's going to get the 200 crores, actually has control over the events that will result in that payment. So to summarize, earnouts and holdback are both very important tools and weapons in an M&A situation, which allow investors, promoters, and the company and the market to A, correctly assess the value of the underlying business, B, allow for indemnification protection going forward, and C, permit the payout of extra sums of money if the business doesn't. Now, let's talk about some concerns here. Obviously, we discussed that in a cross-border M&A scenario, the holdback can only be for up to 18 months, subject to a 25% cap. The problem is now, and what happens and what has been happening in the recent past is that buyers and sellers are global in nature. Particularly in India, there are several instances where M&A transactions have happened which have global implications. So, and this is a purely a theoretical discussion, but let's say I am a foreign buyer, a foreign seller, an Indian buyer, or whatever, cross-border scenario. In that scenario, I know that the total deferred consideration or holdback can only be 25%. What if I contractually agree with the parent company of the Indian entity that, okay, under Indian law, I am only allowed to hold back 25%. 5% additional holdback, or the amount equivalent to 5% additional holdback, let's agree between ourselves overseas. Now that, to my mind, is a violation of Indian law. Of course, it is unethical, but if you look at the law from a conservative perspective, what you cannot do directly, you should not be doing indirectly. So therefore, two groups that are entering into a cross-border M&A transaction in India, if they agree a holdback outside of India between two unrelated entities, and that holdback gets implemented, it is potentially in violation of Indian law. The reason why I'm bringing this up is because I want to let this group think for themselves as to why this is necessary. The reason this is necessary is because the 25% and 18-month cap is artificial. There is no logical reasoning for the holdback to be limited to 18 months or for the consideration to be held back up to a maximum of 25%. What is the RBI's concern here? The RBI's concern, as I mentioned at the start of this discussion, is only a single point discussion. Single point. That when money leaves the country, there needs to be control. That's it. As far as the RBI is concerned, if half the money left today and the other half left 3 years later, this is just a procedural matter. It does not impact the RBI's overall perspective. So my submission here, and also as Pawan sir and Madan sir mentioned at the start of the call, one of the things that perhaps we should feed back to the RBI, to the authorized dealer banks, is that it has been some time since the deferred consideration rules came into force. And to me personally, it makes no sense to have a limitation around 18 months and 25%. If there, and I'm happy to understand if there's a logic, why should it not be 12 and 15 or 24 and 40? As long as pricing guidelines are met, as long as the RBI is made aware, eventually that this was the balance consideration that was paid. And if that balance consideration is in compliance with law, that should be sufficient from an RBI perspective. Finally, and to my last topic, some of you would recall when we started this discussion that cross-border M&A in India could also happen between purely Indian companies that have foreign parentage. So under India's foreign exchange laws, such companies are called FOCC, or foreign owned and controlled. The interesting point that I want to mention to everybody on this call is that if there is a transaction between a purely resident Indian company and a foreign owned and controlled Indian company, that would be a rupee transaction. No money is leaving the country. Okay. So I'm pointing you guys towards the top left-hand corner of the box in front of you. Top right-hand corner, sorry. Transaction between a resident buyer and a FOCC seller. This is a rupee transaction. No money has left the country. However, the law still stipulates that you can only hold back 25% for 18 months. Now let's flip the transaction around. If the seller is a resident and the buyer is a FOCC, again, deferred consideration restrictions or DCR would apply. So the limited point I'm making here is that whenever you're advising on an M&A transaction or about to enter into one or are discussing one, it is integral that you look at the antecedents of the Indian business. And if the Indian business is Indian owned and controlled, sure, fine. However, if it is foreign owned and controlled, you will need to comply with the 18% and 18 months and 25% restriction. And that's just about my time as well. Thank you, everyone. I'm, Santosh, I'm happy to take questions now or at the end, whatever you prefer.
So, Mr. Bhatia, I think there are a couple of questions herein, but how we take those questions later after two more speakers when they are done with, and then we may have the questions if anybody is marking any question pertinent to your session, or we will also have some other alternate like sharing questions to your good self, and then subject to your availability as of now or later, then we can seek your answers to those questions in email or likewise. So thank you very much, Mr. Bhatia, for elaborative, enlightening session and very, very good, extremely very good feedback in terms of people what they're all writing about your this coverage. Thank you so much. Now, may I take the opportunity of inviting Ms. Shweta Bharti, Senior Partner, Hammurabi and Solomon Partners, to talk on the undertaking due diligence on target companies. So over to you, Madam Shweta ji.
Thank you. Thank you so much, Santoshi. And thank you for inviting me for this session. Thanks to Jatin also for taking the initiative. Good afternoon, Mr. Madan. Good afternoon, Mr. Pawan Vijay. Good afternoon, Sujoy. Good afternoon, Rajul, and to all the listeners. So good to be here. Now, I mean, it was a very interesting session that, Sujoy, the entire concept of, the way you explained on the earnout and holdback, I think it was extremely enriching. It gave us a lot of food for thought in terms of, what can be done. And I'm sure ASSOCHAM will also take its own steps in this regard. One thing that, all the speakers have definitely focused and repeatedly right from Mr. Madan to Mr. Pawan Vijay to Rajul, all of them have focused on one very important aspect, and that is, due diligence. Due diligences are something which are critically important when it comes to doing, an M&A transaction. There cannot be any two thoughts with respect to this. And it is important to understand the relevance of due diligence and why and how it is to be done. most of us who are practicing and who would have done the due diligences would have realized what really does it take to do the due diligences. One very important aspect is understanding the target organization. What are we talking about? What is the target organization into? What is the kind of culture that we are talking about? What is the kind of ethos? What are the kind of principles? What is the target company's structure generally? Its subsidiaries, its joint ventures. I think that's one very critical element when we identify a target company. The second more important aspect also when it comes to us as lawyers is to also understand the basic principles of due diligence. And what is it? It is to identify, assess, prevent and mitigate. So these are very important principles when it comes to doing the due diligence. It is also very important to understand what is the sector that we are doing the target due diligence for, because each sector has its own regulatory challenges. So if we are looking at a particular sector, whether it is on manufacturing, whether it is on pharma, it is important to understand the nuances of the sector, and that is important even before preparing the checklist. As lawyers, it is also important for us to understand whether the parent company is a foreign company or not, and whether there is requirement with respect to evaluation of the FDI norms. That also becomes very important and critical. If the organization is engaged in manufacturing activities, I think that has its own host of challenges and checklists to be prepared and understood. So that becomes another very critical element. So the first critical element in terms of the repeated discussion is to prepare an exhaustive checklist. Now, the exhaustive checklist with a requisition list of the documents of the target company is important to be prepared. Once that is done, I think half the battle is won. An exhaustive checklist with all the rules and regulations and procedures that are required to be complied by the target company, if it is there, I think we have, at least done substantial part of the work. But then that is not all. That is definitely not all. And what is more that is required to be understood is that in terms of doing the exercise and doing the M&As, preparing the M&A strategy or doing the target screening on transaction execution or integration, the very relevant aspect is to understand where do we stand in terms of the documentation. So once we have identified and prepared the understanding of the target screening, execution of the confidentiality agreement, we have analyzed the M&A potential synergies, and we have done the submission of the letter of intent. I think Rajul has already covered it. Then is the critical stage where we are in. So before the transaction documents are executed, it is important to understand what are the documents that we are going to analyze, what are the documents that we are going to see. So in effect, it is the due diligence which is like the actual action that we do in this regard. So it is this stage at which involves, as we have discussed, checklist, inspection of documents, compliances of the laws. We have to examine the regulations which are applicable on the target company. And it is the due diligence which is an exercise which opens up the target company across all the operational areas. So it is this phase which provides the valuable insight into a target company's structure, culture, operation, human resources. In fact, it also covers the the supplier customer relationships, competitive positioning, and it also includes the future outlook. So it is this phase where the people involved in the M&A process can reassess their initial opinion on the deal, and whether it is worth considering and further understanding or going into the depth of the relationship. For a proper and a defined due diligence, it is important, and what is important is to understand and develop a target valuation. It is very important to develop an M&A deal structure. It is very important to develop or present and negotiate the M&A deal terms, which my prior speakers have also spoken about. It is also important to plan an M&A integration process. and also to include the all of those matters in the shareholder and other agreements in terms of reps warranties, that we need to identify the red flags in that regard, and then identification of the access and reduction of the risk. So as much as possible, if we are able to mitigate the risk in this regard. So, in doing this, what are the different kinds of due diligence exercises which are required to be done? Of course, it is the financial due diligence, the legal due diligence, the operational due diligence that is required to be done, the taxation due diligence, the intellectual property due diligence that is required to be done, the regulatory due diligences, the IT related due diligences, the EHS related due diligences, the commercial due diligence, of course, this is the primary functions. So all of these important aspects are to be covered in this regard. Now, how is it to be conducted? It is important to understand in terms of the steps, how are the diligences to be conducted? So the first step that is required to be done is understanding of the entity. And that understanding of the entity, both operationally as well as legally, is important and critical to understand the working and the operations of the target company, and to ascertain the proper background of the entity, to understand the environment in which it operates, to understand all the applicable laws in relation to that industry or the entity, and also to identify the areas where the due diligence needs to be conducted. Of course, the preparation of checklist we also discussed just now, that it is an extensive exercise and a detailed requirement of documentation that is to be done. Now, procurement of documents and the review of documents becomes very important, because usually what happens is, and generally what happens for most of the people who are doing the due diligence is, over a period of time, while doing the due diligence, because the documents are so voluminous, we become negligent in terms of looking at the documents, and sometimes the criticality of those documents becomes, which comes into fore a little later. So it is important to be, diligent at all points of time while doing the due diligence. And even if you are the only person looking at a particular document, if you do not raise the right questions, if you do not continue to raise the issues that you have identified, people would never come to know about it. So it is important for those who are conducting the due diligence to understand the documentation, look at the document at the right perspective, and raise the right questions and issues in this regard. The second would be, sometimes what happens also is that while we are doing the due diligence, we start to lose interest because of the voluminous documents. And because of this voluminous documents, if the, and it has a monotonous kind of a tone, so it becomes monotonous over a period of time. But then what happens is that because of this, it also, because of losing interest, there are certain very important and critical documents or information which may or may not be noted in that regard. So it is important that, to negotiate the right representations or the right warranties or the indemnities and the other documents in the M&A context, to continue to have the right interest and the right team to be able to ascertain what is it that we are trying to identify from this due diligence exercise. The third element that we had spoken about earlier also is understanding the business of the company entity. If we do not understand the business of the entity, as lawyers, we will have very difficult time focusing on the issues that may arise while doing the due diligence. It is critically important for us not just to do an overview, but also to understand the business of the client, of the entity. The next important aspect is when we are not able to communicate. One is we lose interest. Second is we may not be able to communicate within our team, if there is no communication within the team to ensure that all the materials which have been received are reviewed, or if we are not able to communicate to the target entity also with respect to certain documentation or a lack of it, or may not seek clarification adequately in this regard, then it becomes, that is an inadequacy in terms of doing the due diligence. So it is important to communicate, and communicate in the right manner at the right time. Now, sometimes we also see that, they're over a period of time, because these exercise also takes a lot of time. So many times we have also seen that the people who are doing the due diligence also lose track of the transaction. So it is important when we are doing the diligence to keep a track of the changes to the structure or the other changes in the transaction, so that we continue to have a focus on the entire issues. And the failure to keep the track would amount to, missing out on very critical issues in that regard. And therefore, the transactions may take several months. And therefore, it is important that the diligence obligations are kept in mind, and the transaction also evolves in that manner. Another important point is to be organized. It is very important to keep a careful track of what has been provided in terms of documentation, and keep a list of what has been provided, what is required, and what are the issues which are required to be resolved, and also a list of the items which are left open to be discussed, and also then keep a track of the next steps that are required to be followed in that regard. That is another critical element which must not be missed while doing the diligence exercise. Unless and until we don't maintain these control measures, it will be, difficult to identify what has been provided and what has been reviewed and what still needs to be reviewed. Then comes the important element of preparation of due diligence report. Before coming to the issues of preparation of due diligence report, it is also important to have a one-to-one meeting with the target entity in terms of addressing of the issues that were left open during the due diligence, in order to give them an opportunity to seek clarification in this regard. And then once you have the clarification in place, then preparation of the due diligence report. Once we have the comments and the replies received from the target entity company officials. Now, this diligence report also in terms of how is it to be structured is very important, because what happens is that we go on and on with narration of a lot of information. So it is important to concise the report in the first few pages, and then give the details with respect to, the analysis that has been done. Because otherwise, if we go on talking about what all documents have been seen, what are the things that have been understood, it will be a long and unwanted exercise in that regard. So it is important to keep it crisp, important to keep it, to focused, and the summary is provided for in the beginning. And the summary can have a cross reference of the pages where it needs to be referred to at a later point of time. So whoever wants to understand the outcome of the diligence is able to ascertain from the summary itself in the first few pages. That is very important. I have seen that commercially it is very important for most general counsels to understand what am I looking at, in the entire set of voluminous document, what is important and relevant to be seen. Now, in terms of, understanding what goes into conducting of the diligence, what is important is to also understand the entire compilation of the diligence checklist. The checklist is a very resourceful tool when doing a mergers and amalgamations. The checklist will assist and cover all business components. It will help to ensure that a proper investigation is performed in order to prevent any kind of delays or complications for the parties who are involved in the process. So if it is a legal due diligence, it is a very meticulous exercise. And this whole exercise covers all the risks, and it also in fact gives the challenges or what are the concerns in relation to the target company's legitimacy or the viability of the entire transaction. So the documents which should be covered in terms of, looking at the diligence exercise, first would be a general kind of a corporate information. Like important is to ascertain the copy of the company's constitutional documents, seek the amendments on the memorandum and articles of association and all the amendments in that regard. Also, the document in relation to corporate organization chart, which would show the holdings, subsidiaries, joint ventures, divisions, branches, descriptions of the operations or the functions of such company. Ask for the list of the subsidiaries, the associated companies, branches, and other offices of the company. List of, the other places of business that the company may have. It also is important to ascertain all the minutes of the meetings. What happens during the due diligence is, if we have missed out on reading the minutes of the meetings, especially the last few years, say 3 years or so, it is important to read through the minutes of the meetings of the board of directors, the audit committee meetings, the executive committee meetings, or any other committee of the board of directors and shareholders for the last 3 years. And also with respect to, the looking at the audited financial statements of the company and the reports of the company for the last 3 years, a lot of information is actually which comes out is from these financial statements and annual reports. Another important aspect is to look at the agreements or the arrangements or understanding whether it is legally binding or not, copies of all the documents relating to all the partnerships or joint ventures or the material acquisitions or depositions. These are important than any other previous schemes of mergers or amalgamations that would have been done or completed or concluded before this in the last 3 years. Sometimes it is also important to look at the power of attorneys because we might miss out on those power of attorneys which may have some very important information in that regard. Then the other important aspect is to look at the list of directors. I think the entire top-down approach, which is important to understand, comes from the list of directors and management to understand who the directors of the company are, what their background is in terms of, understanding what kind of actions have they taken in the past, if there are any liabilities, which may arise with respect to those directors or the persons in management and control. What are the kind of the agreements that have been entered into between the company and those directors, the service agreements in that regard with these individuals, or with respect to any kind of interest that the directors of the management and personnel in transactions which are unusual in that sense, in that regard. Or in fact also look at the list of all the personal guarantees, the loans, the indemnifications, or which are been furnished by the directors to the company. And these documents becomes very relevant at that point of time when we are looking at the criticality of the situation when we are talking about the merger and amalgamation. What happens to those personal guarantees and loans and indemnifications have also to be structured in that manner when we are drafting the SHA and the other agreements. Then it is also important to look at the details and copies of the agreements or understandings that may have been entered into by the management of the business, by the company, including if there are any management fees that have been agreed upon, or appointment or removal of directors, or requirement of quorum for a meeting of the board of directors, or in relation to the structuring of the statutory compliances and licenses, what are the statutory books and records, or the filings that have been made in that regard with the ROC, or with respect to the filings, if it is a listed company, then also with respect to the filings and correspondences with SEBI and the stock exchange of the company, or the promoters and shareholders of under of with promoters and shareholders and SEBI in that regard, or with respect to all the permits, all the licenses, all the registrations, all the NOCs, all the consents that have been received from the statutory authorities, from the local government, or from the state and central government, or for with respect to the commencement of business and conducting and carrying on the businesses, including all the environment related licenses, all the RBI and FIPB related approvals, SIA related approvals in that regard. So these are some of the very important aspects which is necessary to be examined before I mean during conducting of the due diligence exercise. There are also important aspects of looking at the correspondences that the company may have entered into with the government regulators or the regulatory authorities, ROC or FIPB in the past, RBI or SEBI. Look at all the violations of or requesting of the compliance with the laws or regulations, and also in fact asking for information with respect to the compliance with the applicable laws, or with respect to any kind of filings or reportings that the company would have done with any of these statutory authorities. So that is important. What are the kind of improper payments, if it is it is to be highlighted, any kind of improper payment that the company has done to the government officials, or anyone who is acting on behalf of the company who has received a request to make or offered to make any kind of an improper payment, or the company if it has been investigated with respect to corruption related issues, that is also important to be examined. So if there are any such allegations, then those are red herrings for at the time of drafting of the SHAs, and in fact also could be a deal breaker in that sense. Also, it is important to look at the company's books and records to understand whether they have reasonably reflecting all the disposition of the company's assets. Does the company have any off the books kind of an accounts also being maintained? And if that is so, then what is the purpose for maintaining this kind of an account? And then it is also important for the books and records of the company, which may have the appropriate circumstances, the records of the payments which may have been made by the company to the agents or the others dealing with the government officials, or entertainments or travels that have been made. So these are some of the issues which are additionally important to be looked into while doing the due diligence. Besides, of course, the standard items that we need to look into are the share capital, shareholding related issues. All the agreements and contracts, of course, are important and necessary to be examined. Then it is also important to understand, the personnel, the HR related issues of the organization, because it is important to have the organizational chart of the company, understand the strength of the workforce of the company, the location in which each of those workmen are, what is the detailed breakup of the permanent or the temporary employees, how many number of contract laborers are working, how many trainees are there, apprentices are there, retainers are there, and their respective grades. Also, I think it is important to examine the employment agreements or similar agreements or arrangements that have been entered into between directors, senior management personnel, or with respect to their remuneration and entitlements. And also look at the employee handbook in that sense. What are the HR policies of the organization, whether they are aligned with that of the laws of the land or not. And also generally the non-compete clauses or non-compete agreements, or what kind of termination clauses are there, what are the kind of protection of proprietary information kind of clauses which have been provided for in the employment agreement. And also the entire history of the payments or the grants or any bonuses or any kind of a profit sharing kind of arrangement, or any incentive policy that have been given by the company. It is important to look into those aspects as well. Now, it is now if it is a company which also is involved in CLR, the Contract Labor Regulation and Abolition Act, then it is important to look at the registrations which have been given in this regard for the CLRA, and also with respect to the company complying with the provisions relating to CLRA and all the statute and the government or the statutory direction in that regard with respect to employing the laborers through the contractors. Then it is important to also look at all the contracts in relation to the staff or the labor who have been engaged, and the agreement with the independent contractors in that sense. It is important also to see the status of the payment of the statutory dues in that sense, the list of all the payments which have been made with respect to pension, retirement benefits, gratuity, and if there are any kind of litigation which are pending in this regard before various courts, it is important to have a list of all of those as well in order to understand what are the kind of monetary obligation which may fall upon the company, or if there are any other kind of a liability which may arise at a later point of time. It is very important to have an understanding in that regard. Then it is also important to see if there are any restrictions which have been imposed by any court or by any, say, government authority or by any statutory authority also of the company, which may, impact the new owners at a later point of time. And if the company has at any point of time also given an option of VRS, then that is also to be seen. The other set of rules and regulations which are important to be seen are relating to title, because title, land, building, and fixed assets become a very important aspect when we do our due diligence. So it is important to look at all the agreements with respect to any freehold or leasehold properties that the company may have, or if there are any properties which are in the possession of the company, then I think a list of all of those properties are also important to be seen. Then looking at the area, looking at the present possession or control, then it is important to also see what is the recent valuation in that regard, in case it is a leased or a licensed premises. Then the details with respect to the landlords, details with respect to the term of the agreements, if there are any leasehold, then it also about the rent that is to be paid. If there are any procedures for rent review or renewal options, then that is also to be examined. Then it is relevant also to see the the agreements in relation to the all of those properties which are occupied or used by each of the company, which is which is like all the subsidiaries or all the branches as well. So it is not just about the parent company, but also looking at the details with respect to the subsidiaries or the branches, which also is important and which may have some implication at a later point of time in case of there being any violation. Then it is also important to examine the details of any of the properties which would be owned or possessed or
Unable to hear
occupied
now. Thank you very much.
or used by the company, which or any portion of that property which may be taken over by the government at any point of time, or likely to be taken over or acquired by the government at any point of time. Those are also some of the risks that may emanate. It is important to also in fact look at the possibility of encroachment on the property that is owned or possessed or used by the company. If there are any kind of encroachment, or if there are any properties which are lying vacant, what are the status of those the vacant lands. So a comprehensive list of all the lease agreements, all the rent agreements, all the leave and license agreements are important to be provided in order to understand any kind of a liability. It is important to also look at the restrictive covenants or provisions in these agreements, or rules or regulations or orders, or if there are any kind of conditions which have been put, which is to the best of the knowledge of the target company and its officers, which may preclude the use of the properties for the purpose for which the properties have been provided. That could also be an important aspect in terms of examining the real estate related issues. Then, of course, intellectual property issues are important in that sense. If there are any kind of, entire list of all the documents and the applications which have been filed by the company in relation to intellectual property, that also becomes very important to be examined. And all the patent related applications, all the trademark related applications, all the domain names, all the service marks or utility rights or technology agreements, design and copyright, including the international patents, trademarks, copyrights. So the entire list of the intellectual property right related agreements is important, and applications also, in fact, in that regard, which is important to have a look at. Also, if there are any claims or threats or any details with respect to any infringement of the intellectual property rights, it is important to ascertain in the beginning if the company, the target company, has received any kind of a notice or any kind of an allegation in this regard. These are important points to be taken into consideration at the right stage. Or if there are any kind of the agreements that have been entered into relating to the intellectual property as a user or as a licensee, then all of those agreements are also important. And what are the terms and conditions in respect of these agreements, which may have some kind of an implication with the current and the future business plan and prospects of the target company. It is important to look at that. Now, another very critical element is looking at the list of litigations of the company. Litigations of all kinds, whether it is relating to the recovery, whether it is relating to writs, whether it is relating to labor disputes, whether it is relating to real estate disputes, a detailed list of all the copies of the judgments, decrees, orders of the court, orders of the say regulatory agencies, quasi-judicial agencies, settlement of any kind of or current pending or threatened kind of material litigation, arbitrations, awards. These are important to be listed out in the at the first go. And all of these disputes, whether it is initiated by the target company or it is against the target company, the entire list or comprehensive list of all of those issues should be provided, including the description in relation to the governmental investigations or any kind of pending proceedings or inquiries with respect to the company or its affairs, details of the notifications, if any, that the government would have come up in this regard. All of that is important to be sought and examined in order to understand what kind of implication it may have on the entire mergers and amalgamations. Then, of course, there are some relating to insurances as well, the description of the D&O and other liability or the indemnity policies that the company would have taken in that regard. The The other important aspect is the environmental licenses, because environmental health and safety becomes a very critical element when it comes to doing the mergers and amalgamations. So all kinds of a list of licenses, permissions, authorizations, and consents with respect to environmental authorities are important to be sought, and ascertain copies of all kinds of health and safety related policies that the organization may have. It is important to examine that as well. Whatever are the types of emission and discharge or release of the hazardous substance, in case the company is engaged in the business of hazardous substance, then in that sense it becomes even more important to look into those aspects, or any kind of a material waste which is released into the air or into the water. All of those important aspects are to be examined at the beginning in order to be able to understand the implication in that regard. Then also in relation, it is important to ask for the copies of the compliance certificates which are issued by the company, or any environmental statement which which is filed by the company in pursuance of any environmental law or regulations. So these are some of the important aspects which are required to be checked in order to be able to conduct the due diligence in that sense in detail. Now, if we look at what are the practical challenges which comes up when we are conducting a diligence? The practical challenges are, if somebody has not prepared the relevant questionnaire. So if the questionnaire has not been prepared in a proper manner, and if somebody is not asking the right kind of questions and decides the direction in which the due diligence exercise will go, then the entire due diligence exercise can go completely haywire. And therefore, it is important to spend as much time in the beginning of the preparation of the questionnaire or the checklist, so that we are able to save that much time subsequently, either in litigation, or in the deal entirely falling apart, and the company losing a huge amount of money in this sense. The second could be, in terms of challenges, is slowness in execution, because if the whole due diligence exercise may even take a couple of months. In some cases, we have seen it taking more than 6 months in terms of the completing of the entire process. And in some cases, we have also seen that the target company has been completing the compliance as we are doing the due diligence, and because of which there was a very very slow pace in terms of movement when it came to document sharing and communication with them. So it is important in today's time to understand that it is the compliance has to be at the topmost in terms of priority. So if it is not a compliant company, the target company is not a compliant company, there will be an extremely slow process in the execution of the due diligence exercise in that sense as well. Sometimes also poor communication plays a very important role. So if somebody has a very poor communication, then the entire due diligence exercise becomes a challenge, because then they are juggling between one department to another, between finance and legal department or HR department, in order to get the proper coordination, get the information or documentation that are required. So for that, it is important to have a clarity of thought and a clarity of communication to provide for the details that are required, and to put your foot down at some point to ask for those documents. And if the documents are not available, and somebody is trying to comply during the process of the due diligence exercise, I think at some point we have to say no to that. And many a times I've also seen while doing the due diligences is that the companies have inadequate information. The companies do not provide for adequate information, or provide for just bundle of information, and then it takes a hell of a lot of time for somebody who's doing the due diligence to identify, segregate, and then take out the correct information. So the intention is deliberately also sometimes to provide for inadequate information, in order to not provide for a truthful picture that is there. Then sometimes it is also the lack of expertise of the person who is doing the diligence, which may can be a deal breaker, because at a later point of time, if there are some identification of issues which may really impact the diligence, then those are some things which have not been covered in that sense. So there have been instances in the past, many instances in the past, with respect to inadequate or inefficient kind of a due diligence. One which was a very famous one is that of Hewlett Packard, which had carried out only 6 hours of due diligence in the finances of the British software company called Autonomy. And it was before buying that for about 8 billion pounds. It was a deal that ended in a disaster, and about 5 billion pounds of fraud cases were initiated against HP. But what had happened is that HP had failed to notice that the accounting improprieties which were there in during the diligence exercise, and it was because of that that it was sued by the shareholders for negligence in missing the red flags and not performing adequate diligence related to the purchase. In fact, there was another case which is also important. Is I mean, and there are many cases in that sense when the 2G license was revoked. It was during that time also a lot of companies who had invested into these telecom licenses. It also, in fact, because of doing the inadequate diligence in the process of the companies detecting the impropriety which was involved in obtaining the telecom licenses. All of them had to subsequently face different consequences, and the matters are going on before the arbitrators in BTAs. So it is important to understand the importance or the relevance of the diligence, why we do diligence, and it is the stage where the actual action begins with respect to assessing the target company, and it is based upon the happening of the successful diligence exercise that the acquirer company is able to take the right decision in that regard, and is able to proceed with the deal, how to proceed with the deal, and what are the areas where he has to negotiate, what are the clauses that he needs to put in that sense. And if it is a well-conducted due diligence exercise, it is an integral part of the successful M&A transaction. Any kind of a negligence or any kind of inadequacy in that sense will have a detrimental effect on the entire M&A transaction, and it will either be a failed M&A transaction, it will have a severe financial implication at a later point of time, and of course, legal hardship in the process. So it is important to avoid any kind of inadequacy in the due diligence exercise, and it is important to focus with the right team who understand the operation of the target company, who prepares the proper checklist in that regard, and then prepares the questionnaire in that sense, and asks the right questions, communicates in a right manner, and prepares their due diligence report adequately in order to be able to understand and then implement in the shareholder agreement. So that is my two bits in this sense. Thank you so much for for giving me this opportunity. Thank you.
Thank you, Madam Shwetaji, for your wonderful, insightful discussion and presenting your perspectives on the subject of due diligence. And thank you very much. We may have few questions after the my last speaker for today's technical session. We have with us Dr. Sanjeev Kemavat, Group General Counsel, Vedanta Group, to share his vast experience and insights on M&A issues, challenge, and way forward, how the industry is responding. So we may request Dr. Sanjeev Kemavat, sir, to please take your session. Over to you, sir.
Thank you, Santosh. Thank you, Santosh, for inviting me, and I would like to thank ASSOCHAM for inviting me to share my views. I think M&A has always been a relevant topic. Mr. Madan, good evening. How are you? Okay, so M&A.
Dear, nice to see you here.
Same here, same here. Great. So I think M&A has always been an interesting topic, very relevant and contemporary topic, not only because it has fetched monetary benefits to consultants, advisors, lawyers, but also because it has also created certain entities in India who were who became ultimately the global entities. So the way in which I look at the M&A and the topic which has been given to me is issues, challenges, and way forward. The way in which I look at the M&A is that it's nothing but a reflection of the state of the economy. And when I say that the state of economy, determines what kind of M&A transactions would happen, and you can understand this. And if you take the example of last 30 years, you will notice that various consolidation happens in various sectors of the economy. If there are sellers of a business or undertaking or company, then there are takers also, acquirers also for those very businesses. And in the recent past, in the last nearly 7 years, we have also experienced the insolvency and bankruptcy code, because that is also a state of reflection of the economy. last 30 years, we have seen various consolidations happening in almost all sectors, whether that be banking sector, there be, the power sector, pharmaceutical sector, telecom sectors, cement sector, and so on. All these acquisitions, all these consolidations, they happen for a reason. Either the organizations wanted to become big and wanted to become a global player, or perhaps they were in financial difficulties and somebody else thought it appropriate to acquire those businesses and run those businesses. There are various examples of those success stories. If I talk about my organization, the success story, the initial disinvestment of the government of India of the public sector undertakings like Hindustan Zinc and Balco, and which was acquired by Vedanta, I think those are the very true success stories that how the organizations can be run so successfully after acquisition by the private sector. I think these are the true real stories in terms of businesses getting revived, businesses becoming big, and businesses becoming global players. So I think this is how I see the M&A. Largely, the way in which I see the M&A is three forms of mergers and acquisition. One, mergers and acquisition, which are basically internal restructuring, which M&As, which is mainly arising out of internal restructuring, consolidation of one or the other entities. So this is one form of M&A activities. Another form of M&A activity is arising out of the needs of the market. Somebody wants to sell its business and somebody wants to acquire that business because somebody looks at that business with a high level of optimism, perhaps. So this is a second kind of activity. And the third kind of activity of M&A, which is largely now arising out of insolvency and bankruptcy code, either through liquidation process or the corporate insolvency resolution process. Largely, if you notice that all these forms of mergers and acquisitions, one or the other legal framework would be impacting this, whether that be company law, that can be securities law, taxation laws, that can be insolvency and bankruptcy code related provisions, stamp laws, competition law, and so on. But at the same time, there would be always industry specific laws also. If you are in the mining sector, then mining laws, environmental laws, there would be pharmaceutical related laws, real estate related laws, or one or the other legislative framework would be impacting these various mergers and acquisitions, or the way in which the whole process of M&A activity would be carried out. Now, this legislative framework determines that what kind of issues and challenges come up. Now, if you notice that these legislative challenges pose problems for us, and the problems and issues and challenges are largely can be divided into three parts. One part is, of course, whatever we do in terms of structuring of the transaction, whatever we do due diligence. So I would classify that into before the actual M&A process gets started, that kind of activity, which is, I would classify that under before M&A. One is during the M&A process, what kind of issues and challenges, and the third is the post M&A, once you acquire the property, then what kind of issues and challenges come up. Now, if you notice that these issues and challenges which come up at different points of time in these various segments, they are largely arising out of two parts. One is because of the commercial issues, and the second part is because of the one or the other government or regulatory issues, or the process of the mergers and acquisition. Now, Santosh, I just wanted to know what's the time schedule you have. I can take 5-10 minutes more and then Q&A, or
Yeah, surely, please take
okay, fine,
your time,
fine.
sir.
Perfect. So I think the issues and challenges, they are largely arising out of one or the legal other legal framework, and that legal framework poses a problem for us, and or the challenges for us in terms of predictability or certainty of the whole M&A activity. Now, there lies the problem. The industry suffers from this part, that there's a lot of uncertainty or unpredictability in the whole process. And why I say so, the uncertainty and unpredictability, because all these processes get run under a legal framework, under a legal process. And that legal process is largely, for example, under the company law, the section 230 or 232 and so on. It's all adjudication process. If you are looking for acquisition or M&A activity under IBC, so that under the IBC process also, there is a process involved, adjudication process involved, which is basically NCLT, NCLET, and so on. Now, just think about it. When I say that there is a different forms of M&A, whether that adjudication process at times is required or not. It appears to me that this adjudication process itself is posing a problem in terms of uncertainty with regard to time, in terms of uncertainty with regard to cost, in terms of uncertainty with regard to the quality of judgments. So there's a huge risk involved, and above all, in all these processes, you will find that one or the other so-called vested interest, they would keep on interfering in the adjudication process, and those cases, those kind of issues get entertained under the adjudication process. So I think those are the major issues and challenges which normally industry faces. Now, and of course, let's not forget that but the under the quote unquote the public interest terminology, under this public interest, anything can get entertained in in terms of whether public interest litigation or one or the other frivolous applications, and that would completely delay the process. Now, I'm aware about this fact that thus, yes, we are not in a perfect market. We are in an absolutely imperfect market where there's a information flow is not perfect, where there are vested interests who would be looking for the benefits, in their own way. So there's a lot of issues and challenges. But then, how to take care of those issues and challenges, and the way in which I look for the next steps or the way forward, and particularly when we are discussing this particular matter in the ASSOCHAM umbrella, but it gives me an opportunity and and taking this liberty also to suggest something on that. For example, the internal restructuring. Now, an internal restructuring, which is where you have the approval of the shareholders, you have the approval of the creditors, if you have the approval of the tax authorities. Now, why that should undergo a long process of adjudication before NCLT and NCLET, and why then in that process we invite those kind of elements in terms of filing application and all that. The whole process gets delayed because of the frivolous applications getting filed. The point which I wanted to make is that internal restructuring, where there is no impact on anybody, where where the consents are already in place, why do you need the whole process of adjudication? In fact, the way in which I look at the NCLT process, it's not adjudication in that sense. It's just a registering a certain facts on record and then giving approval. The fact remains that all mergers and acquisitions, wherever the companies get transferred or undertakings get transferred, the process is that all assets and liabilities are getting transferred. Now, in a situation like this, why do you have the adjudication process and keep the whole process so complex and complicated, which leads to absolutely delays in terms of the approvals? The second part comes in terms of M&A activity under, as far as the business part is concerned, where there are at arm's length the buyers and sellers are there. Now, I think that is, of course, a process which needs to be taken care of in terms of NCLT and NCLET approval process. But largely, as I said, that there are always industry-specific laws. You enter into an M&A activity, but then there would always be elements under different laws which would be posing problems to you. For example, if you have the mining lease transferred from one entity to another, the state would say that you have transferred this, though it may be under the mergers and amalgamation, though it may be under the internal restructuring, but then the state can very well take a stand that we are cancelling your mining lease because you have transferred it, you have not sought our approval. Now, one point of time, how many times, how many authorities a party would be seeking approval, the fact remains that the assets and liabilities are getting transferred, the company is getting transferred, or the undertaking is getting transferred. Now, it is not only limited to only the mining laws. Even if you take the real estate sector, there also you will find one or the other form wherever the leases are there, or wherever the government concessions are there, the government would take the stand that there is a change in control, there is a transfer, there's a change in the board, and on those flimsy grounds also, all your M&A activity would be put to stall, or even if you have completed the process, you would face the problems in terms of how to run your business in the times to come when there are so many litigations. Take the example of IBC. IBC we have all experienced. Post-acquisition, I'm not talking right now on the pre-acquisition state or during the CIRP process, there are lots of confusion in terms of uncertainty and unpredictability of the whole process. But even the post-acquisition also, there would be one or the other government department raising demands, and you will keep on showing them the judgments on terms of SR Steel or whatever the legal precedents. But then in mufassil areas, people would not be the local authorities would not be understanding this. The state would not be understanding this. So there is no harmonization right now in terms of various organs of the state or various organs of the central government and local authorities and all that. I think that awareness is needed in the system. So the way in which I look at it is that the way forward can only be the simplification. Some of the processes which I strongly believe, they are not adjudication process, they are just a registering process. Let those be a time-bound registering process, so that at least the M&A activities would not be put to stall. And ultimately, let's accept this reality that any delay in the economic sphere, that is costing the nation. We are not helping the nation building. I think this particular thought should be there in the minds of everybody. So I think this is what my broad comments would be. As an investor, anybody would be looking for fair and equitable treatment. I think that is what the key, and that needs to be understood by all those processes. All those parties or all those authorities who are part of the ecosystem. And I'm observing this from lower level to the upper level, that sensitivity is lacking. And there, I think from an ASSOCHAM standpoint, those issues can be raised at the appropriate forum, so that some objectivity, transparency, or some kind of sense should prevail in terms of the whole process. So this is what briefly I would like to comment, and I'm open in terms of any questions or clarifications on this. Thank you, Santosh.
Thank you, Sanjeev sir, for your practical insights and sharing the experience as well. And we would love to have your perspective further going forward in case if we are supposed to be putting forward to the government. Would love to receive your these perspectives as well in written form. Likewise, we have done in the past in several such instances with various regulatory bodies.
Yes.
By the way, I have been receiving a few questions here in maybe that you and co-panelists can answer these questions. One is from Ganesh. He asks how to deal with tax notices which may be received after the conclusion of the deal. Can an indemnity clause protect the buyer? Can this be taken by someone? Or if you can please guide.
So you're putting this code, but as Shweta.
No, go ahead, Mr. Kemawat.
No, I think look. You always structure your contract with all those indemnity clauses and so on. But then again, it's all a litigation process, which party should be aware of. I don't want to give any idealistic answer in this. These are the realities of life. That despite of the best of the document, you end up having litigation. Only thing I can suggest is that you need to be cautious about it, and that is what I was just hearing Shweta earlier. That your due diligence should be impeccable. and that would only help. And then coupled with the right structuring of clauses, so that would only help. But the fact remains that these issues ultimately lead to litigation, and you need to be mentally prepared for that. It's a long journey, and that is what the difficulty I was conveying, and that there are lots of issues and challenges because objectivity would be lacking on that. Yeah.
Yeah, so what I would suggest in this kind of a situation is, see, tax implications are when you have done the due diligence exercise, you have identified the tax liabilities in that sense, and you have put it in your reps and warranties accordingly. So once you have put it in your reps and warranties and you have an indemnity in that regard, there is a lot which can then be attributed to the target company and the promoters of the target company in that sense, to bear the consequences of the tax notice that is received after the conclusion of the M&A transaction. Because even during the M&A transaction, if you are going through the court route and if NCLT is involved in that sense, the notice goes to the tax department. So if there is any kind of implication that has to be given, the tax department will also raise their concerns before the NCLT as well. So in cases of NCLT related transactions, I think that is taken care of before, and therefore when you are taking over, the acquirer company is starting on a completely fresh slate in that sense. That's my two bit.
Thank you. We have one more question that is in context of HR perspectives. Mr. Venkat Sharlu asks the question. This is the question pertains to human resource retention in the transaction deals, and he asks further that whether the retention of human resource can be held on ground of the performance in such transaction deals.
I can take this. So there in a typical acquisition scenario where the selling shareholders are also key employees, you have two options, right? So if there is a key employee who is also a selling shareholder, then the holdback or the earnout that I discussed makes sense, because that key employee would want to continue with the business and continue to do well for the business until their deferred consideration or holdback or earnout is paid out. This becomes trickier when the key employee in question is not a selling shareholder. If he was just a key employee who held certain share, who held a good position in the company, but was not a shareholder. Typically, what companies do is to bind them through a stock option program. So post closing or after you acquire the company, you could perhaps initiate a stock option plan wherein these key employees would be offered options in the company which are linked to performance. So those are the two ways that you can do this.
Thank you, Mr. Bhattaji. One more question comes that seeks to answer from someone that that's very interesting. Looks from perspective of independent directors. What should be the key points independent directors should capture in any M&A deals? Any responses to them?
Independent directors, they are not required to capture anything separately. I mean, whatever is captured by the organization, the acquirer company. Acquirer company, once they have taken into consideration all the factors that are relevant for undertaking the due diligence exercise, independent directors would not have a separate role to play. Independent directors would have a role to play when it comes to the entire process of during their tenure as an independent director, whatever are the non-compliance or whatever are the checks that they have realized has not been met by the company, that they have to highlight before the board of directors. But so far as M&A transaction is concerned, there would not be a separate kind of identification of concerns that would be raised.
But I would like to only add one thing, Santosh, here that particularly in all those, structuring or restructuring kind of transactions, particularly internal restructuring, and otherwise also, what independent directors should be very careful about the valuation of the assets or valuation of the company. And that is the key. That is the key. And whether for that they will have to have their satisfaction in terms of the reputed and a valuer to be valuing the assets and all that. Because normally, if there are issues, then the questions would be raised on the valuation part. So I think from independent directors, this is one advice I can give, that they should be slightly careful on that in terms of getting the right kind of people valuing the assets or the company or the undertaking.
Absolutely, sir. So perhaps this question would have been in the backdrop of some cautious approach to be followed by independent director. Maybe like the person asking question is himself or herself as an independent director, so that they are cautiously taking care of their position in themselves. Thank you very much. One more question that's there is, considering the implications involved in M&A deals, including the approvals from the competent authority, how much time does it invariably take to complete the transaction? Please, if you may answer in reference of some of the law and practical approaches in the recent past.
So, of course, there are lawyers sitting here. They can give the timelines and all that. But then I can only say that I have seen examples whereby NCLT takes its own sweet time of 1 year to 2 years. And above all, it's not sufficient. The matter goes to the NCLAT also. NCLAT takes its own sweet time of 3 years and set aside the whole acquisition. So without staying the NCLT order. And there is no law available whereby how to a company which has been closed, concluded, wound up after the NCLT order, how to revive those companies. But NCLT has passed those kind of orders. NCLT has passed those kind of orders also. So the experiences would vary. There are always some positive examples whereby some approvals have been received in a shortest period of time. I don't deny that. There are always exceptions. But then there are cases of this nature also, whereby the approvals have been granted, companies are closed, but again the orders have been passed of setting aside the NCLT order. So the experiences are very varied, and that is what the challenges I was referring to.
True. I think more or less that is what our experiences respectively also would be, that the kind of time that is being taken by NCLT for approval of a M&A transaction is just too much, and a lot of it can be curtailed if we have 100% approval from the shareholders and creditors. I do not see there to be a reason for insistence for a meeting even thereafter, and because we also come up with the concept of public notice. So any which ways, if any of the parties have any concern in that regard, the public notice is adequate to cover the objections. So if NCLT is taking so much time, I think it is completely unwarranted, and there could be some recommendation in that regard from ASSOCHAM to address these issues definitely, because timeline is a very critical element. A lot of mergers are getting stuck, and since IBC has come, I think the authorities tribunals do not really have the time that is required to give priority to M&A transactions. So all the company matters, all the M&A related matters have taken a backseat, and because of the precedence of IBC. So I think Mr. Madan was also mentioning in the morning that he has met the NCLT president. Hopefully something good will come out of it, but something that ASSOCHAM could also do in this direction, definitely.
One development has been there, that in Delhi, in all the 6 benches, at least 1 day in a week has been dedicated for company matters.
Right, that's great.
Right, and that's right, Mr. Madan. We've heard about this, but like for example, in Bombay, this was done where 1 day was kept only for merger matters and insolvency matters. But we are working there on 2-3 matters, and the update that we get every day from there is that only for the first half, the NCLT works on merger matters. The second half, they don't come up for the hearings. So what is happening is, and when they come up, they only take insolvency matters first, thinking that there it is an urgency, and for merger matters, obviously, then they are pushed. So we've been getting adjournments which have a gap of a month. So just by 1 month, the transaction gets extended.
What is
Great.
happening in those
that's-
cases, you know, the,
yeah.
the bench members are sitting on the one bench pre-lunch, but post-lunch they are presiding over other benches. That's the problem. That's the problem that we don't have sufficient number of members.
Availability
It's
of
not that in the same bench they are taking other matters post-lunch. That's not happening. But post-lunch they are sitting in other benches. That's the problem.
absolutely. You're right, absolutely.
And
Yeah.
we should represent to ministry from ASSOCHAM and mentioning about the cases that merger cases are pending since last 1 year, 1.5 year, and then we should request them at what is happening, because insolvency means Supreme Court, Parliament, everybody. Merger mean is companies, small companies, they think company का कोई role नहीं है. So let's work out. Professionally उसमें हल्ला करते रहते हैं. Let's work out and we should give a representation to government, MCA.
पवन जी एक और suggestion है. There's one more suggestion, Pawan ji. मतलब this all mechanism of first motion, second motion, all redundant processes. Do we really need that? What would you do? You just fix a date after 2 months, and that date is just advising that you hold this meeting and that meeting, and after 3 months again you are again coming up. So all these are redundant processes, and this particular environment, at times I think these processes are not needed, and I think some representation should be made where a person is coming with all that shareholders approval in place, creditors approval in place, departments, income tax departments approval in place. Just register it, approve it, and move forward.
You mean to say, Sanjeev, in the first, when we are filing first motion,
yes,
I think they should issue, and then they should tell, go to shareholder, go to income tax, go to RD, ROC, or whatever authority is there, and income tax, and then come with all the orders, and we will pass an order.
Yes, and the point which I wanted to make is just give us 60 days time to everybody that if you want to make any representation, make representation and just pass the order. These are simple mergers. Right? Two parties are ready, two parties are already involved. Why do you need all that process? Yeah. And another thing which I wanted to mention, I think it's the right time since Pawanji, you and Madanji and everybody is sitting. This whole game of minority shareholder. Now the best of the transactions, they get compromised because you are playing in that majority and minority rule. Now, why the minority shareholders, so-called, they cannot be put the transaction on hold, So I think this I am invariably seeing in almost all sectors, and whatever the proxy firms would be advising, and based on that, because it's all impacting the industry. It's all impacting the larger consolidation of the companies. And if the consolidation is not happening, then we are not producing global players from India.
संजीव, इसमें ना थोड़े से different views हो सकते
वो हैं, उसमें होंगे, but I agree that. I'm not denying this. But then those can always be addressed in one form or the other. But I'm on a larger picture. That some correction should happen now. These are just becoming obsolete laws.
I think after listening to all, because my video was off, but I was listening to everybody, and it was a very nice discussion. Let's conclude the issues. First issue is that in India we are not getting funding. That is a larger issue which we should write to Finance Ministry. Second issue is that the change in company law and in place of first motion, second motion. Third is the NCLT issue, which are dragging the entire merger issues. Fourth issue relating to SEBI point. That first listed company has to go to stock exchange, then SEBI, then they will do it. Then you are going, then again you are going back to the stock exchange SEBI. So is it possible that we should file by first motion? They should issue notice to everybody, including SEBI, and then whatever objections they have, they can file, and then merger can take place. This is one point which we should write, because SEBI has their own view. Next point is, which is a serious point, which earlier maybe you have come across all the professional. Earlier, SEBI was allowing like you are doing merger of a small company with a big company. Okay, so the what was happening, the equity which you are issuing, the equity cannot issue more than 75%. So you are issuing either convertible instrument or warrant. Now today SEBI is saying whatever you are issuing, which is in future, it will be calculated 75% today. Now in this case, in these types of cases, what is happening? The Indian companies are in loss because you are not getting funding. You are having this type of arrangement and this type of mergers. So Indian company cannot buy the big company. Okay, so this is another issue which we can raise to the SEBI, which I think all professional must be facing, whether it's a Sweta or Sujoy or you must be feeling Rajul also, these type of cases or other cases which you people can give, we can compile and send it to the respective ministry or respective authorities, including income tax also. Income tax is also the advocate of the income tax. It is not following the law. They are taking time. And the court is giving time on time. They are saying continuously they are giving 2-3 adjournment on income tax issue also.
Just one
Again,
more suggestion from my side, sir, that we need to also look at the fast track merger process. While we have a section under the Companies Act for fast track merger process, can we just, I mean, if you really see how many such fast track mergers are really happening? Because the condition that is prescribed under that section for fast track merger is so strict. Unless you are not 100% wholly owned subsidiary, you can't go for a fast track merger. We need to relax the conditions there because sometimes I may not have 100% subsidiary, but I may have group companies. It may be a group restructuring that is happening, but because I'm not able to fulfill those conditions, I have to go through the normal merger process and wait for 1.5 years for me to restructure my company.
Santosh, can you tell somebody to jot down all these points?
Yeah, definitely. We have these all, recordings done, and we will take the, these in written form. Can you repeat, sir?
I'm just asking Sweta if she has any suggestion.
No, yes, in fact, that was the primary suggestion that I had, and I agree with Rajul on the fast track merger because it has not been successful because of only reason that there the terms and conditions that have been provided are stringent. So if we are for group restructurings, we really don't need to comply with that 1.5 years of the NCLT procedure. We could probably expedite the the process by a fast track merger adoption. That is these are things I think important is to also, in fact, we can add the point of IT also, because IT department takes a hell of a lot of time in giving the approvals. If we are able to have some kind of a deemed approval concept, and it is already there, I mean the legislation provides for a deemed approval, but then that is not accepted by the NCLTs. So if we are able to a push in that regard, because this is a new addition. Earlier we never had the concept of getting the IT approval in the beginning, but now IT approval has become a mandatory requirement, and IT department has been recovering a lot of its old dues, which are also contested dues in the garb of getting the approval. So we are pushed. We don't have a choice, but sometimes to just pay off those old dues and get the approval, because otherwise the entire M&A process gets stalled. So I think that is also another important point to be added.
Okay. So Joy, you have a point?
Sir, I think mostly it's been covered, but just sticking to the topic that I was talking about, there is, to my mind, there is a clear gap or clear gray area around the applicability of holdback or earnouts to FOCC companies. Every M&A lawyer who does cross-border M&A is aware there are, and I think there's a question by somebody called Anuj as well, and he's absolutely right. It is a matter of interpretation. So rather than lawyers trying to interpret what should be a prohibitive legislation, it would be great if the RBI issues a clarification in this regard, And the recent master directions were very helpful in certain aspects. But I think it's very important that complex M&A does not suffer by virtue of people taking different views. And I can say from personal experience that it is no longer good enough for us to take the view of the relevant authorized dealer bank because they themselves don't know the correct position. So, to my mind, if we can issue a letter or representation to the RBI asking for clarification around the restrictions applicable to FOCCs, that would be very helpful.
Um, Thank you very much. Can I request Madan sir to please come in and give your remarks, concluding remarks as well? And then there will be one more interesting question which could be of interest to everybody out here except Sanjeev sir.
And what is that?
So it should be taken first, right?
Yes.
So this question is asking based on experience of each one, and this question pertains to some of the basic idea background was given in the background concept note slightly with regard to the cost component of the M&A transaction, which professionals do charge. So the question is written here by one of the participants based on experience of each one of the panelists.
Discuss this.
Advise the way one professional could indicate the estimate of fee from its clients for assisting it in M&A transaction. Is it linked with phase wise or payment against certain percentage of agreed consideration finalized in advance based on overall estimated cost of takeover bid, something like this? So the question directly asks about the professional charges or fees with regard to M&A deals.
I think Santosh, this answer, nobody can give the answer of this question first.
But just a rough idea, is there any like as per the merchant bankers rules which are prescribed by the regulatory authorities concerned?
So,
Maybe something.
nobody has prescribed that how much you charge and how much you charge in pieces. So nobody.
I think, the simple answer, Santosh, is that respect the professional. We need to
Yes.
respect professionals. Yeah, I think,
I think
that's what,
yes.
depending upon what kind of context we have or issue we have. Yeah.
Absolutely.
Respect, yeah.
Sometimes the transaction is very simple. Sometimes the transaction is very complicated, and the professional advise saving lots of money in taxation or stamp duty or other thing, or you are getting something great. So that you can't value on that is, and this is a system. Suppose you go to, these are the 4 or 5 professionals are sitting here. You go to, everybody will give a different way out, and you can.
So
Companies
there is always cost benefit analysis where the participant can evaluate.
Yeah.
So Madan sir, over to you for your quick comment and concluding remarks.
My concluding remark on the fee or otherwise?
No, otherwise, overall.
Overall, it has been a fantastic program, and I agree with all the panelists as well as my chair, Mr. Pawan Vijay, that this is the high time we prepare our recommendations and go to Ministry of Corporate Affairs. I tell you, there is no other point of going to any other body.
Yeah.
We must go to Ministry of Corporate Affairs, and we must have our own analysis done. We must have our own comparative study done. What was being done earlier and what is being done now, and how actually India could be benefited as a country, as a whole, economy as a whole. How can we benefit it if these M&A issues are taken up on priority by the government, the regulator, as well as the judicial forums? I think for this, we must have brainstorming first amongst ourselves. Maybe you can form a panel. We should have brainstorming, prepare our report, prepare our recommendation, and then we should go to the Ministry of Corporate Affairs. Actually, that will be in the interest of not only of the companies and the professionals, but in the interest of the company as such, in the country as a whole.
Surely, sir, we can take this up, and likewise, we used to do the council meeting. This task force can be invited. Other members who, of course, are not in this particular session, they can also be invited with their views. and submissions they have in their respective organizations, maybe sector specific or in overall views. So then we put this in holistic manner altogether to you, and then
We must tell the government that ease of doing business should not be on papers only, but it should be in practice also.
Yes.
surely.
Perfect. Thank you very much. Thank you.
Thank you very much. Thank you.
Everyone.
Thank
Thank
you,
you.
Thank you,
Pawan sir.
everyone.
Thank you.
Thank you, Madan sir. Thank you, Sanjeev sir.
Thank you. Thank you.
Thank you, Rajulji. Thank you,
Thank you,
Mr.
everyone.
Bhatia. Thank you. Thank you, everyone. Participants may be requested to send your further questions in case if you have to ask to any speaker. We will pass on and then connect you for the answers. Thank you very much for having all of you with us this evening. Thank you so much.